went to the court applying for what he calls retrial. But now, it's the man who tried, in fact, who pleaded on behalf of the 5 individuals. Should he be the one? Is he the appropriate lawyer to file for a retrial? We'll be looking at that tonight when our guest comes, and of course, going to go detail into what's happening, happening at the court involving Jefferson Kamau, Yanti Tuan, and the rest of them, because there's some, in fact, legal interpretations that Samuel Twain and the 2 others may likely be dragged in if the case is called. But there are others who think that it's not possible because the jurors had to already adjudge them non-guilty. But we're going to look at that tonight again. This case is a high-profile case, and of course, it has become a major talking point in street corners and in major gatherings, public radios and all of that, public gatherings. And so we all have to talk about. Until we can see the analysis of the case, we're going to talk about it until our people can be well educated. And of course, we'll be looking at also jury trial. Has that been bastardized? Do we need a reform for jury trial? Because, we can remember, often there's jury trial, someone will cry foul. Jurors didn't treat us fair and all of that. So we're going to look at that when our guest comes tonight. But David, let me welcome you quickly. You're always the first to enter studio. Welcome to the program.
Thank you, Sabo, and good evening to our many listeners and viewers. I'd like to say good evening to my fellow panelists who haven't come yet. But I guess Moses is almost on or will be getting us soon. So good evening, Sabo. Even I'd like to say good evening to you and our technical people in the background.
Okay, thank you, Tabwe. Let me welcome Desmond, rather. Welcome.
Yes, sir. Thanks. Good to have me, and let me say good evening to everybody. And so those of our people in the radio land, it's good to always come to educate you about those things that matter. It is important that we always take of our time to come so that we can better provide the necessary education that you need. Because remember, it is your right to access to information. So our role in society is to make sure that you are informed, and not just that, but you are informed reliably, and that the facts are all with your believed. So it's great to be here. Support you wouldn't have said it any much better. So and we look forward to having a very fruitful and engaging conversation this evening.
Okay, let me also welcome Yusuf Sharif. Yusuf, welcome to the program.
Good evening. You getting me?
Yes, we are getting you, Yusuf. Welcome.
Yeah, good evening. We want to say a very big thank you to all of the panelists, including you, big brother, Silver George. I think it is very, very important that we come out every time to speak on national issues affecting our country. And it is good to be here this evening.
Okay, welcome. We really appreciate you being on the program. It's Moses. Okay, we're still expecting Moses, Sandy, and George Kennedy. They both have not yet joined us. As soon as they do, we're going to ensure that we can, join them as well. But let's try to play this tape. Something happened today, gentlemen, and I think let's begin with that. I know by 8:30, our guests will join us, and then we'll go into the major discussion for today. But let's just do a little discussion around this. Yeke Koluba, the expelled representative of district number 10, right? Today he he made a visit. He paid a visit at the Capitol, and he was asked by the journalists. But let's play the tape so that at least you can see for yourself and listen to what he had to say to the journalists. Let's play that.
Stay alone. Stay alone.
I think I want to see somebody say they still I can for what?
You say you want to
what
see
did you want to do?
The chief clerk.
Well, I went
what did she say?
Chief clerk is all of the country and the deputy chief clerk is in session, so I need to do a communication on my letterhead I'm going to do that communication, asking them that I need to renew my diplomatic passport. I need to travel on Monday.
But
I actually have to travel on Monday.
you
so.
think they will grant you that?
Well,
Because
if they don't grant it, it's up to them. I'm not going to fight them. That's the procedure. The procedure is I write, and I'm going to write. I'm going to use my letterhead as representative of district number 10 to write a communication. If they deny, it's up to them. We're not up for fighting, bossman. We got places to go to get redress, and I will do.
You have been expelled, but you're still requesting diplomatic passport.
I've been expelled. They can't ask vacancy. Some of your gentlemen are very stupid. That's the problem I got with some of you. Yeah, General.
the matter of when the court is expected to rule.
Well, we can tell the court when to rule. The court will decide when to rule. We respect the court.
Correct. I just now, the point is, please, the point is, Dave and Desmond and Yusuf, I know the rest of the team will shortly join us. It's Yeke has been expelled, and like you listen to him, he said he went to see the chief clerk to see whether they can give him the opportunity to renew his passport. This is a man who had been expelled. And he said he's going to write to the House of Representatives using his letterhead as representative of District 10. Let's hear from you, Tabla. Is that possible?
The first thing, he doesn't know what he's talking about.
Okay.
You suspended. You know, not suspended. You're expelled from the legislature. That means that you're not part of it.
Mm-hmm.
You are not part of that legislative body. So, what sense does it make, for you to use a letterhead as District 10 former representative? To seek the renewal of your passport from your fellow colleagues at the House of Representatives, where you've been expelled. The other thing is, I'm wondering, whether is the responsibility or is the yes, of course, it's the responsibility of the House of Representatives to renew Yeke's passport, diplomatic passport. I think that's forcing the purview of the Ministry of Foreign Affairs. It's the Ministry of Foreign Affairs that renews passports, not a House. I don't know from which context. I don't know from which context he's speaking.
Apparently, what happened at the House is that if a lawmaker is supposed to travel, he takes his traveling document, his passport, and other things to the chief clerk, and then she writes a formal communication to the Ministry of Justice, the Ministry of Foreign Affairs. But the point is, and let me
no. Before you go to somebody else. No, Sabo.
No, please, we get it.
Sabo, before you go to any other person. Look, Sabo. There's.
Yes, well, go ahead.
Yeah, so Yeke Koloba is, as I said, I don't know what the law says about who uses diplomatic passport and who doesn't. Yeke, I believe that as a former member of the House of Representatives, was entitled to a diplomatic passport because of his status in society, right? Now that he has left the House of Representatives, the legislature, he was expelled. That means that he isn't a member of the House of Representatives. Is he entitled to a diplomatic passport? What does the law say about that? We have to establish that before.
But his point is, the matter is still pending. It has not been actually been resolved.
But which matter hasn't been resolved?
He's expelled. He's expelled.
So exactly, that is the point I pointed to have making when you come in. So the thing is, just as we have the Supreme Court, which is the final arbiter of justice, that court has the responsibility to restore sanity and to resolve whatever matters of illegality. So the first thing of contestation is Honorable Yeke Koloba, as far the law concerns, as far the Supreme Court is concerned, he is still a lawmaker. Yes, of course, he is still a lawmaker. So just as he is still a lawmaker, he is entitled legally to be treated as a lawmaker.
What are you talking about?
No,
That
come
doesn't
here,
make
come here.
sense.
Do not-
What are you talking about?
do not
What are you
eject.
talking-
No,
It's
wait,
still-
please,
No,
1 minute,
what
1
is
minute.
it? No, let him
1
not-
minute, 1 minute.
Let him not allow this guy to waste
1
our
minute, let
time
them
here.
land.
No,
Let
it's
them
not
land.
wasting our time.
So
What is he talking
No,
about?
1 minute, let them land, Dave.
What
I know,
are you
I
talking
know,
about?
I know it may be the uncomfortable truth, but we must confront it.
I'm not feeling uncomfortable. What I'm
Yeah,
talking
get-
about
Let
is
the man
that
land.
you
Dave.
are not making
No,
sense.
Dave, no, you can't say the man.
No, he's not making sense.
No, the man, you have your right to speak. He
Well,
has his
I
right to
thought Mr. Tagbe is supposed to respect your colleague.
Okay,
Go ahead.
I knew you would have come in.
Go ahead, go ahead.
So you can see for the obvious reason that the House of Representatives still have to honor the decision of the court, of which they are still doing. So just as the case is still in progress,
He still remains a lawmaker.
he is still guaranteed honor the law as far as the Supreme Court is concerned that he is a lawmaker.
Okay, let me hold you there. Comrade, today Yeke took a visit to the Capitol. We just played that video. Unfortunately, you were, I'm sure you were walking in. We'll play the video. And he said he went there to request the chief clerk to facilitate the renewal of his passport because he's supposed to be traveling on Monday. So the point is Yeke still a lawmaker? Is he entitled to that?
First of all, you got to look at history. Which member of the House that ever, or the legislature that ever been expelled and they enjoy diplomatic passport? You see, there are certain things.
But no, but the matter is still pending now, comrade. The matter is pending. As far as he's concerned.
Which member of the House or the legislature that ever been removed? While a speaker, while a who? They went to court and the court
No,
said,
but the court hasn't passed on it.
That's weird. I'm
yes.
saying something.
Mm-hmm.
Which member of that legislature that ever been removed, the matter went to court and that person remained? You see, that's a separate branch of government. That's the first branch of government. A lot of people missing this thing. Now, Yeke went to file bill of information. Voila, the people say that they didn't see the stay order that you sent. Whether I stay lawmaker or not, they said they took the action. That bill of information. Wherever you go, Yeke is out. I told you this. I don't let him waste my time on the kind of matter. He won't get it.
Okay,
the House, the Speaker, will nobody will affect the Chief that will not do it.
Let's hear from Yusuf. Mr. Sheriff, you listen to the video that we played. What's your thought?
So here's the issues. Legally, we believe his colleagues expel him from the Honorable House of Representatives, and for the fact that they expel him, they can file a bit of information to the Honorable Supreme Court. Until the Honorable Supreme Court can speak and say, hey, gentlemen, listen, Honorable Yeke Koluba rights were violated, he stay a lawmaker, but until then, based on their own rules and what they carry on, Yeke is still considered as an expelled member of the House of Representatives. So in so doing, you cannot be not a member of the House of Representatives and still be applying for a diplomatic passport because the law is clear. Only people who are representative or official of government, cabinet minister, are entitled to a diplomatic passport. So until the Honorable Supreme Court can speak, the judge in Timor Justice Kaba, as far as some of our concerned, whether we like it or not, Honorable Yeke Koluba is still an expelled representative. So he's not entitled to a diplomatic passport.
Okay. Moses, let's hear your thought on this.
Look, let me greet everyone first. It's indeed a pleasure to be back. This is a very interesting discussion. Look, gentlemen, we have to be nationalists. And besides that, we are media people. When we speak to educate. So sometimes it's good to put the party sentiments behind you, and be a nationalist. In the legal world, it is often stated that anything that is not done legally is never done. It's never done. Article 38 of the Constitution provides that before someone is expelled, such person is given due process. This man did not get due process. I'm not saying that. Several other individuals, including Senator DeLong, Senator Amara Kone, lawyers have all spoken on this issue. It is clearly spelled out in there It talks about due process. Due process as laid down in the Constitution of Liberia is a constitutional guarantee. It triumphs the rules of the House. This man did not get there. He has a case in court, and somebody want us to erroneously believe that the man is expelled. I mean, what is this?
You know, this is the problem I have with Moses.
This is
the problem I have with Moses.
Dave, Moses still in speech. Gentlemen, we are only talking for 6 minutes because our guest will be joining us anytime.
I heard.
Moses, try to learn.
One more point.
You know, I think we need to send Mr. Tagmet to, you know, for what we call, no, not mental health. We just need to do some drill with him on social etiquette.
You know,
yeah,
you know,
yeah. We don't talk together.
Very interesting.
Please, the man is still speaking.
So what I was saying is, the law clearly provides for that. This is not Moses saying he's saying it. And what is happening?
Okay, so
so let me say this. What is happening? Yaka Koluba is still representative Republic of Liberia because the matter is now before the Supreme Court. And gentlemen, the current situation we're talking about is indeed a litmus test for the Liberian democracy. It's a litmus test for the rule of law in Liberia. Thank you.
So no, wait, Kennedy. The first
that 4 minutes, our guest will be joining us. Our listeners and viewers will have Councillor Abraham Sila as our guest tonight. He's the managing partner, of the Heritage Partners and Associates. We'll be looking at the debates concerning or debates around the much talked about economic sabotage case. You'll be answering some of our questions and some of the concerns that the public do have. Yes, let's hear from you.
The first thing, Moses who talking about misinformation and disinformation. And that's the same Moses who's misinforming the people that there wasn't a due process leading to Yeke's expulsion. I remember Yeke, the leadership of the House of Representatives asked Yeke to come to face whatever committee they had with his lawyer. And Yeke was accompanied by his lawyer. They went to the House of Representatives. Wasn't that a due process? He and the lawyer walked out unnecessarily, senselessly walked out. Then at the end of the day, Moses says in Delaware, in the United States, and misinforming the people that there wasn't a fair trial, that Yeke wasn't a game. That's a blatant lie.
Okay, George.
That's a blatant lie.
That's a blatant lie.
1 minute.
Mr. Sandy can sound, because most of them were walking on the street. Other people can ask, so who's that man? He can sound so comical on the radio.
Comical? What do you mean?
This is the man we discussing issue. He said, put your political. So you are opposition. So you are sedition, because every day he prays George Weah now. But let me say this, Mr. Sandy, to you.
No, he has not praised George Weah.
Oh, that's what he does.
No. Sandy has not praised George Weah.
No, he has not opposition camp.
No, he's not in the opposition camp.
No, listen, please.
Sandy is a professional journalist.
He's not a journalist. He's not a journalist.
All right, go ahead.
Let's speak to this. Because every time someone disagree with him, all go, put your political feeling one side. And so because he disagree with him. So I want to tell him that he's opposition. For me, he want to call my name, I will tell you so. So the truth is, Mr. Sandy, we can give you instances on this particular matter. The latest, the last one was the speaker. You said it was against the rule of law, they blah, 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 blah. That one died. The speaker remained member of the House. This one, we're telling you from practice, the court would not go force the House because that's two separate branches but coordinating. The House will not interfere in the judicial matter. What happened to Prophet Keys? The House did not interfere. The court used their rules to punish Prophet Keys for 6 months. He's in jail. The court will not go tell the House, say, reinstate former representative, Yeke at all costs. Let's wait and see again. You will see the one. Maybe you will still be learning because he said you covered the house before.
So Yeka is not entitled.
Yeka is out, and he is not entitled as we speak.
All right, I'll get to soon, Jonas, gentlemen.
Yeah.
So I continue to say this is the comfortable that I must confront.
Yes,
so
just give me a few seconds. Let me make a little bit of correction here for my brother.
If you allow me to talk, then I will have to talk back.
1 minute.
So people are
1 minute.
political.
Gentlemen, 1 minute. This one.
So I mean, it seemed to be so pathetic, wherein people would perceive that Yeka was given a due process. Excuse me. Who told you that due process is just about the sudden appearance or the one-time appearance of Honorable Koluba going to face the investigation by the committee that was designated? Due process is a gradual process from one stage to another. So if Yeka have gone to the area, then ask ourselves, what was the outcome of that meeting? Was the investigation conducted? No. Yeka raised issue that I need to be represented by my lawyer, which they grant. And the granted. As a matter of fact, his lawyer was there. He said, I need to speak through my lawyers. They denied that. I said, we were also his constitutional right.
Just information to him.
Information
to my colleague on the show. Because people do not mislead. People want to
Judge. So we are waiting our guests.
Yeah.
So I can remember vividly, Yeka and his lawyer walk out. Yes, it is true. And what did it go out? Because Yeka, in his honest opinion, and based on the video everybody watched, Yeka lawyers, they were all denied access for speaking. So if you don't want them to speak, why ask? If you don't want the lawyers, if the committee that were investigating Yeka never wanted Yeka lawyers to have spoken, why? And allow the men to invite his lawyers into the meeting.
So the information.
That is one of the issues. Then the second issue, which is very, very uncomfortable, is how will you say because this has been in practice as a common doctrine, but you fail to ask yourself whether that common doctrine is the right doctrine, whether that common doctrine is the legal doctrine. There are laws. We cannot run a house that will be very lawless. We're gonna have a legislature that will be so senseless to the very law that they are responsible to make.
Okay.
So you cannot be making laws that are simply breaking the laws. But let me say this: as far as the court is concerned, as far as legality is concerned, Yeka Koluba still enjoys the privileges and the right of an honorable man.
Okay.
The whole shouldn't attempt to deny these access or these privileges. They will be also infringing on his right as a matter of fact.
But let me come in.
1 minute, Moses.
Moses, just listen to this information. Yeka is not a freshman lawyer. He's 9 years. Lawmaker. He was 9 years in the House. He voted for the rule that says when a member of the House is being investigated by the body, that member of the House is entitled to a lawyer, but that lawyer can speak. That lawyer can speak through that member. He's a signatory to it. That's the rule of the House.
Provide the education for this.
So if my friends don't know this, when they went in the House, it's not just about yelling to the microphone. It's about the real issue, right? Let me tell you this.
No, discuss what you believe.
Yeah, so not what I believe is factual.
Okay, just speak your opinion.
I don't care how you yell to the microphone and get a whole newsroom noisy. It won't help the process. The process is the process. So when you, the lawyer, when that I said all that time, I said the lawyers, the first thing they should have done was to have asked for the rules. They didn't. That's why the former chief justice really surprised me. You should have seen if he has seen the rule, they had a lot of ways to delay that hearing. I'm not a lawyer, but I would have gone there and said, look, please offer me the copy of the rule through my representative and say, then we can come back to
all right, so gentlemen, let me announce. Most of them just announce this if I can come to you. Moses, 1 minute, Moses. Very shortly we'll have our guest studio. He sought to just drive to the studio instead of coming online. So he'll be in studio very shortly. Councillor Ibrahim Sila, and of course, going to look at some of the debates concerning the economic sabotage case involving Tued and others who understand that in fact the the jurors already came down with the verdict, but there's still more questions than answers. So we are, we've been endeavoring to bring on board lawyers, seasoned lawyers, astute lawyers to come and educate our people as to what's happening concerning this landmark case. So very shortly, Councillor Abraham Sila will be in studio, and we'll have our discussion up to 10. That is 9:30 this evening. But gentlemen, listeners, viewers, you can share the show. We want you to share the show. We are streaming live on our Facebook and our YouTube channel. Just tap Nighttime Heat, and of course, you're going to follow the show online. Besides, we are also streaming live on the Prom FM Monrovia 105.5. Yesterday, we had Councillor Jerome Verdian, a Liberian lawyer based in the U.S. He was on this program, and we're trying to just provide education, provide information for our people, because there's lot of misinterpretations in the public concerning this case. Moses, you can come in now quickly.
Yeah, thank you, Saba. I want to say something to my brother Kennedy and Mr. David Tagbert. Gentlemen, I cannot stoop to your level. I am beyond that. When David Tagbert sits in Liberia and referred to me, Moses Seni sits in Delaware, that's very condescending. But I'm not going to elevate David Tagbert. No, I am beyond that. When Mr. Kennedy sits in Monrovia and say my views are comical, that's his opinion. But one thing he forgets to know is that I don't talk loosely. My thoughts are always coherent. I make sense. I come across as an educated person. I don't talk because I'm a member of the UP, no. And let me tell you, let me throw an open challenge to you, Mr. Kennedy. And there is an open challenge to all of you in that studio. If any of you come up with a publication or any document that links me, Moses Sandy, to any political party in Liberia, I will give you $1,000 US. It's a challenge for you.
All right, Moses, thank you, Moses. One minute, no, wait, one minute. One minute, George. One minute. Please.
Why were you saying
no?
And listen, calling David Campbell, you get sued to him is too low.
George, 1 minute.
That's arrogancy.
1 minute, but because
no,
1 minute.
Don't do that.
No, please, 1 minute, Dave. I mean, no, I'll mute your microphone. 1 minute. Let's hear from you. Moses, you are still speak.
Yeah. Let me reiterate again. We come here. Allow me, my man. Let me speak. I told you. You do not know.
No. Listen, George. Don't do this. We have not come on the show to make light of the public discourse.
See what he did today. Did you stop him?
I'm coming. 1 minute. We have not come on the show to make light of the public discourse. People are watching and people are listening. If your friend is in speech, kindly allow him to speak. When he learns, then you can come in to speak. Moses, go ahead.
Okay, let me teach a little bit of ethics for my man Kennedy. Just as Mr. Sober told you, when someone speaks, whether you agree or disagree, in civilized society, we listen. You listen keenly. When a person completes, then you speak. If you don't do that, you come across as crude, primitive, uneducated. When people conduct themselves like that. So I'm simply saying to you, it is an open challenge. Let me throw the challenge again to you. Kennedy, you raised it. If you come up with any documentation that links me to any political party, I am doing an open challenge to you. I will give you $1,000. That's it. Let me stop there.
Okay, so 1 minute. Wait.
I gotta
Wait,
respond
1
to
minute,
this.
gentlemen. I know.
I gotta respond to this.
No, wait.
Stop.
Tagbo wants to respond.
Yeah.
Okay,
You yourself
now,
want to respond. Tagbo, you can.
Thank you.
You know, the first thing is that
We are awaiting our guests and listeners and viewers.
Saba,
Very shortly, our guests will be in studio. Yeah, why?
Saba, how can Moses sound like that? You know, Moses is sounding like a freshman in intellectual discourse. It's a freshman intellectual discourse. I respect that guy a whole lot. But besides, you know, put aside my criticality. But I respect Moses. But what Moses to have come up to say that, oh, I mean, he's educated and he will still be on a level. That's nonsensical. Look, if you can't stand the heat, Moses, leave the kitchen. This is the nighttime. This is the nighttime heat. That's what the show here is called. You should expect. You should have a thick skin, Moses. Don't stop being emotional when the discourse becomes tense. Moses, put aside your emotions. This is an intellectual discourse. We're not here to scratch your back or make you to feel happy or hear what you want to hear. We are discussing the issues, Moses. You sometimes misplace your logic. You sit over there and you're boasting of being educated. But yet and still, you sound like a freshman in intellectual discourse.
All right, you've done your response. Let's hear from you.
That's unfair.
Moses ended before you could say to somebody, David hasn't ended.
But David had just ended.
No, he was in flight.
David had just ended. No, David has ended.
You know, I understand someone. I don't have
So the truth is, Moses feels he's so educated. He feels 1,000 is too plenty for him. Moses, I'm not one of those guys in the media that you will come for 1,000. If you want it, I can send it to you. I can send it to you. You understand? But let me say this to you.
What's your order?
No,
wait,
please,
David.
Please, man.
We here.
Our guest gets around. We'll shortly,
if you are on the show and someone expresses his opinion, and one thing you have to say to them is, you're not here for their political opinion. And for you, you're not a politician. But you have repeatedly said on the show, from the beginning, you said you voted for Akai. And you have repeatedly said that you now stand on that you used to hate so much. He's the main person that you can quote today. A lot of contradictions on your Sunday. You have now leaned to the opposition and say, oh, the government plundering. We're countering it. If you can't, because you live in a luxury in Delaware, according to you, I don't need to go to America to live good life. I don't need it. I don't need to go do clinical work in America to live good life. I live right here. I'm happy. Your clinical work you're doing, you're earning your resources. It's for you, Moses.
Thank you,
so that I send you $1,000. No, I cannot. Let me end on this. I give you $1,000. $1,000 below me in Liberia. And let me say this to you finally before I can close on this. Let me say this to you finally before I can close with you. You know, you need to understand that we are not here to pamper you. We're not here to agree with you what you say if or you are distorting the fight. When we tell you this, you are not in Liberia. You're hearing from they say also in social media. So we continue to educate you. You have, yes, when you're saying something that makes sense, we tell you, yes, Moses, you're right. We've been saying that before. But if you can't want to attack people when people express their opinion, you want to link them with a political party, of course, we can't.
Okay, thank you, George. Thank you. Gentlemen, we just have to play this video. Yeah, 1 minute, please. Moses,
for the show.
Our guest has just.
Can I make a point?
I know. That's Yusuf.
Yeah.
Yusuf, let's hear from you quickly.
Yeah. So here's the thing. I'm begging everyone. That's the issue. I know there are some people who feel here about what somebody said to them, but it'll be very important to see. So here's my point. For me, personally, I don't support the way the legislature proceed in telling Yaka Koluba, but it is a independent branch on their own. They are already active. Until, like I said, I maintain that position until the Honorable Supreme Court can speak.
Whether you like it or not, this is not about our feelings. It is about what is happening. Whether you like it or not, based on their own rules, Yeke Koluba is already expelled. Until the Supreme Court can say, gentlemen, look, your actions were this, were that. Until then, Yeke Koluba is an expelled representative. That is the point I'm trying to make.
Okay, thank you. So, gentlemen, on this program, basically, we agree to disagree. We'll clash verbally on this program. It's no one should take offense. How you see things is not how I will see it. How you believe it is not how I'm going to believe it. So please let's keep the bond together. Sure. Now that we have our guests in studio, let's try to introduce our guests quickly, and then we get into the discussion. We know our guest is Councillor Abraham Sila. He's one of the astute lawyers around, very esteemed, highly respected. He's the managing partner of the Heritage Partners and Associates. He's our guest tonight. You know, there has been a lot of legal misinterpretations. In fact, since this whole economic sabotage case started, and then the misinterpretations, in fact, increased when the jurors handed down a verdict exonerating Samuel Tuet and 2 others. So those misinterpretations have continued to make rounds on social media in major gatherings. So we just thought that we have on the program, legal minds to come and explain to us how do they see the case and how they think prosecution performed, how they think the defense performed, and the jurors as well. And in fact, we're going to even hear from them whether the issue of jury trial should show, should be something of the past. We need to do reform, because every time there's jury trial, some kind of noise will come and people are dissatisfied. And so we're going to ask all those sort of questions. Let's have our questions, our hard questions, that we can ask Councillor Sila tonight, so that you can also understand. Yesterday, we had Councillor Jerome Vradio, a Liberian lawyer based in the U.S. He gave his own. He weighed in on the matter yesterday. So it's tonight we have Councillor Sila, and of course our viewers. You can share the show, share the live video. We are streaming live on Pram FM Monrovia 105.5. We are also streaming live on our Facebook page. That's the Nighttime Heat Facebook page, and also streaming live on our YouTube channel. That's the Nighttime Heat YouTube channel. Just tap Nighttime Heat, and of course, we're going to follow the show tonight, and it promises to be very interesting. Councillor Sila, welcome to the program tonight.
Yeah, thank you so much. Thank you so much. I appreciate the invitation, and this is my very first time. I am really delighted by the fact that you were able to have me here tonight. Thank you so much.
Okay. Now, let me just inform you that I alone will not conduct the interview. We'll have other panelists, Mr. David Tawet, the man close to you there, Desmond, George on the other side. We'll have one of our panelists in the diaspora, Moses Sandy. He's in the diaspora. He also asked a question. Likewise, Yusuf Sheriff. And so Josh alone will not be interviewing you. We'll have others to ask questions. But let me get the ball rolling, Councillor Sila. Since the verdict, there's been a lot of misinterpretations regarding this whole economic sabotage case. I'm sure you are a lawyer. You've followed the case. You have a vast knowledge as to how the legal process went and some of the political implications as well. Let's hear from you, your take on what you actually observed since this whole case started.
Yeah, so thank you so much. It's an interesting question. Firstly, I must say many thanks to you all, my colleagues, on the panel here tonight. I was very much moved to have accepted the invitation, and thought to come over because of the many views in the public. Some who are street jurors, others who are lawyers, party litigants, and the rest of them giving different views as to what the law is. And as a lawyer, I think it behoves me, to the society to be able to come and make some clarifications as to what, may have obtained. I am not here as a caveat to give any opinion on what the jurors may have taught and or what the jurors may have taught, and or whether there was any error under the circumstances or there was any irregularity under the circumstances. I will not speak to any of those. And I will limit my comments basically to what is now in the public domain, because there are other processes in the matter that are subject to legal proceedings. So I will limit my comments and my own view of what I think the law is and what is in the public domain. So you asked my view about what has obtained. What I do know is that, of course, yes, I did follow the proceeding to an extent up to the date of the verdict of the jurors. This is how our system works. We have situations where the defendant in a criminal trial has a right to a jury trial. In fact, generally, constitutionally, everyone has a right to a jury trial. But the emphasis is placed in the criminal proceedings. So the defendant will determine as to whether he or she waives his right. Because under our laws, if you have a right, you have a right to waive your right. So in this case, the defendants opted for a jury trial. Good. I think there's a misunderstanding here fundamentally, because some of the members of the public are still making references to the repealed jury law or the amended jury law. So under the current jury law, which was amended in 2006, we'll have the new jury law. That new jury law reduced the number of jurors from 15 to 12. And it further says that the verdict, to obtain the verdict, you must have 5/6. 5/6 of 12, it means you must have 9 jurors who will agree in order for you to have or for you to sustain a verdict. That verdict could be guilty or not guilty. You must have 9 out of 12, not 15. It's no more 15. Secondly, it means that if you were to get less than 9, then it's a hung verdict. All right? So it means that in the circumstances of this case, there were multiple offenses. And the new jury law says that if there are multiple offenses and there are multiple defendants, for each crime that is alleged, the jury must make a determination as to whether the person is guilty or not guilty with respect to each offense that is alleged in the indictment. So you will see that there were multiple offenses and there were multiple defendants. And so in the mind of the jurors, Samuel Twere, not guilty, right? And I think the controller of the FIA, not guilty. And then there were 3 other individuals. In their view, Councillor Twere, guilty. In their view, Stanley, there were Stanley Ford, all right? There were hang, and I think on one offense, guilty, if I'm correct. And then that applies to Stanley Ford. I mean, not Stanley Ford, but Camo, the former national security advisor as well. So what it tells us that the jurors made a determination that 2 persons not guilty of all the offenses charged in the indictment, meaning that they are free. Councillor Twere, guilty. Stanley Ford, it means that those specific offenses where you see hang, meaning that there was less than 9 persons and the jurors could not agree. You could not get 9 jurors to determine guilty or not guilty. So they were divided. And because of that division, it means that there is a hung verdict, meaning there has to be a new trial for all those offenses where you see hang, there has to be a new trial in the case of Stanley Ford. In the case of Camo, similarly, if there is any hang there, it means that there is a new trial for hang. Where there is guilty, the judge will pass on those guilty verdicts. But before he does that, the defendants do have the right to file a motion for new trial. That is, those who were brought down guilty. And not on the hang. Where you have hang, you have no right for a new trial. But where you have guilty, in the case of Councillor Twan, Jefferson Camo, and Ford, three of them, where there is guilty, they have a right to file motion for new trial, which I think they have already done. Under those circumstances, the judge will hear that motion for new trial and determine as to whether the verdict is consistent with the evidence. The judge reserves the right, and it is a discretion. He may agree that the verdict is not consistent with the evidence, and he can set aside the verdict and order a new trial. In the case of those three individuals, he can at the same time agree that the verdict is consistent with the evidence. Therefore, he will confirm the verdict and render a judgment. In that instance, he will sentence those three individuals. Of course, they have a right to take an appeal. In the case of Samuel 12 and that of the former controller of the FRA, their matter is not subject to any review by the judge. The jurors have declared them not guilty. So the motion for new trial, the public must understand, the motion for new trial does not include Samuel 12 and Cooper, the former controller of the FRA. Now, the critical point most people have asked, and I find it difficult to hear many people, giving kind of different opinions about it, which are inconsistent, some of which are inconsistent with the law. Under our laws and practice, when the jury in a criminal case comes down with a non-guilty verdict, it means technically the matter has come to an end. When it's a non-guilty verdict, it means the matter has come to an end. But in the mind of the prosecution, and I can read their mind to say from experience, when you hear some saying that the matter has not ended in terms of Samuel 12 and Cooper, their reading goes to the constitutional provision under appeal, which makes it a right to every individual and the way the Constitution is written. Under our statute, the state in a criminal case can take appeal in only two circumstances. Okay. One, where there is a judgment of acquittal, where they file a motion for judgment of acquittal, meaning during the trial, when the prosecution has produced evidence and the defendant feels that the evidence is not sufficient to connect him to the offense, or the prosecution has not established or linked him to the commission of the offense, he has a right to move for judgment of acquittal. Under the circumstances, the judge, reviewing the evidence, may agree with the defendant and acquit the defendant. In that instance, because there was not a full trial conducted, the state may take an appeal from there to the Supreme Court. In an instance where the indictment is dismissed for defects in an indictment, the trial has not started, but the defendant moves the court to dismiss the indictment because there is a defect in the indictment, and the court agrees and dismisses the indictment, set the defendant free. Even before trial commences, the state can appeal to the Supreme Court under that circumstance. Those are the two circumstances. And the two circumstances I've given you are statutory provisions. They are not constitutional. Now, this is where the state is coming from, or those who are reading the statement are coming from to say, in the case of Samuel 12 and Cooper, the matter has not ended. Under the Constitution, Article 20, I think 20A or so, or B, everyone has a right to appeal. They say appeal is invaluable. And the legislature must enact laws to provide expeditious manner in which everyone will be entitled to an appeal. It does not distinguish between the state, which could be a party litigant, or individuals or organization, it means everyone is entitled to an appeal. Wow. So in the mind of the prosecution, they are also entitled to an appeal. But the statutory provision, the 1986 Constitution talks about appeal. The statutory provision that limit the state right to appeal in only two circumstances were enacted in 1972. So if the 1972 statute prevents the state or limit the state right to take an appeal in only two instances, and the 1986 Constitution grants everyone the right to an appeal, the state is saying or may say that the provision of the Constitution trumps or takes precedent over the 1972 statute. Wow. So under the circumstances, they are saying, even though those statutory provisions limit our right to take appeal in the two instances, under the Constitution 1986, we are entitled to an appeal. Then the question there is, how do they pursue the avenue of getting an appeal? Because for you to be able to get an appeal, you must announce it on the records. They could not have announced an appeal from the verdict. Your exception, you only note exception from the verdict, not appeal. So on the day the verdict was given, the state may have noted exception to the jury's verdict. Now, how do they get this appeal against the two defendants who are acquitted but have not filed a motion for new trial? That is a critical aspect. Wow. If we were to ask them from our own professional standpoint, is that they have one way by which they may be able to get that on a record. That would be when the judge shall have heard the motion to dismiss of the three defendants who filed a motion. Whatever way he decides, he has to render a judgment. When he's rendering the judgment, he will have to indicate in the record that in the case of Samuel Tua and this person, the verdict is now guilty, right? In the case of the other two persons, whatever he decides, whether he will set the verdict aside for a new trial or he concurs with the verdict, affirm the verdict, and sentence them, he renders a judgment. It's at that point that the state will take advantage of to announce an appeal. Assuming in his ruling for the motion for new trial, he agrees with the verdict and sentences those guys, he will render a judgment. That going out of that judgment, the state will may announce an appeal. And if they announce an appeal and mention specifically the two defendants that have been acquitted, the judge will be inclined and should, I will be surprised if he doesn't, the judge should deny, because under our laws, under the statute as provided for, there are only two instances where the state can take an appeal. So in that instance, the judge will deny the appeal, then they will only have a right to a remedial process and not the appeal. So they will seek a remedial process first to seek to the Supreme Court to review, not the Supreme Court in totality, but the Chamber of Justice to first review the judge's denial of their right to appeal under the same constitutional provision I just mentioned to you. Under that circumstances, the Chamber of Justice will determine as to whether he agrees with them and issue the writ and have a hearing and make a decision or not. If the Chamber of Justice decides that, look, I do not agree with you, the matter is terminated. If the Chamber of Justice agreed to say, yes, what you say makes some sense, it raises a constitutional issue, therefore let me hear you, or because it raises a constitutional issue, I alone should not hear it, let me elevate it to the full bench, then the full bench will have the opportunity to hear the particular matter relating to the two defendants that were acquitted. But if the state does not take advantage of any of those avenues, it means the matter in the case of the two defendants that were acquitted is completely closed, and they should never be permitted to answer to it any longer in their lives.
So let me come in before my colleagues can come in. So the state, because the argument is the fact that the jury or the jurors had already handed down their verdict, the matter is closed. Now, you are telling us tonight, and you really explained it well about a 1972 statute and 1986 constitutional provision.
Yes.
Now, if so, it is those two, meaning the 1986 constitutional provision, that the state can rely on to still hold consignment well.
Well, they may rely on it to seek a relief under the circumstances to say that they are also, or they also have a right to appeal a judgment of not guilty. Not necessarily, you may go,
it's hooking him.
Yes, the intent is to have him hooked.
Thank you.
But they will be seeking a relief and a determination by the Supreme Court as to whether the state may now be granted the right to an appeal. It is after that determination that the court can assume any right to hear that non-guilty verdict. Other than that, the court is precluded from hearing that non-guilty verdict. Am I saying to you, the only way the state may advance this before the Supreme Court is by way of a remedial process. And that it means that the state has several barriers to overcome in order to reach the full bench of the Supreme Court. Firstly, they must be able to make a notation on the record as to the appeal with respect to those two defendants who were acquitted. The judge, to all intent and purposes, should deny their right to appeal. It means that there is no appeal. So they will now accept to the judge ruling denying their right to appeal.
And run to the Supreme Court.
And go to the Supreme Court on a remedial process, meaning they go to the Chamber of Justice. They go for a writ of certiorari to review the judge's denial of their right to appeal. That will be the single reason they will go there. And if the Chamber of Justice agrees with them and decide to have a hearing and or elevates the matter to the full basis that they have raised a constitutional question, then they may have the opportunity for a right in setting the guys free. No. It's not whether they should re-arrest them. No. It's not whether they should answer to the offenses. No. But whether they, as party litigant before the court, under the 1986 Constitution, Article 20, they also have the right to appeal.
Yes.
Thank you
George?
very much. This has been one of the main areas that I've been confused in, and you have made it very clear to me tonight. And thank you for broadening my mind. The Constitution, there is a provision in the Constitution that says any law to the contrary is null and void. Okay, so what now can we say about the 1972 Act? Because probably it had not been tested in the Supreme Court, right, to see whether it is null and void. That particular provision in that 1972 Act. In your opinion, what now can you say? Because the Constitution is a supreme law of the country. It says all parties have the right to appeal. So then what becomes the status of that 1972 Act that restricts the state, in your opinion, because
yes, and this is the beauty, about the law. It needs to be tested, and I'm aware of at least two situations under which it was tested under different circumstances. If you are familiar with the Monarchier and other skills, Monarchier and Prince, the late Prince Akirelli, with respect to the uniform, theft of properties, economic sabotage, and all that. I was one of the consultants at the LUCC at the time. We prosecuted that matter. So what happened is that there was a verdict of guilty against the defendants. But because they had a right to a motion for new trial, they filed a motion for new trial, and Justice Kaba, now Associate Justice, granted their motion for new trial, set aside the verdict, and ordered a new trial. So what we did was to have appeal for his decision.
Was it a bench trial or jury trial?
It was a jury trial. Okay. So there was a jury verdict of guilty in that case. And then they filed a motion for new trial. And then he set aside the verdict and ordered a new trial. So we representing the state at the Sunday LCC, we now move we appeal his decision. No, because our interlocutor, we didn't appeal his decision. I'm sorry. We now went by way of certiorari before the Chamber of Justice in order to review his decision. And so the Chamber of Justice agreed. Justice John then agreed. And then the Supreme Court heard it and said he was in error to have set aside the verdict and order a new trial. When that was done, he was ordered to reinstate the verdict. So the verdict was reinstated, and then now the appeal went for the court to hear it, for the full bench to hear the appeal. But those two circumstances are not analogous. They are not analogous because in that situation, there was a guilty verdict against the defendants, and a motion for new trial was granted. In this case with Samuel Tweh and Cooper, there is a non-guilty verdict. So there is no opportunity for a motion for new trial for the state from which the state may take any exception in the case of the two individuals. It is only the three individuals that filed a motion for new trial.
Okay.
So getting Samuel Tweh and Cooper into whatever appeal process or whatever remedial process they will want to seek as a result of the new trial is the catch for the state. How do you get them? Because they did not file a motion for new trial. What they may rely on is when the judge renders a decision, and in his decision include the non-guilty verdict of Samuel Tweh and Cooper, acknowledging it and setting them free that they would not answer to the charge now and forever. It's on that note that they may want to take an appeal.
Now, before we go to McCulloch, let me ask this question. And I want you to be practical and honest, when you're answering this. If you were the legal counsel
for the state,
no, not for the state, but for the defendant, for Samuel Tweh and the rest of us, and the verdict came down by the jurors, would you have advised that he stay out of any celebration because the matter was not over totally, or would you have given him his free will to celebrate?
Well, I think the response from Tweh and others was natural. It come out of a natural instinct.
Yeah.
When you find yourself hooked up in such a situation, $6.2 million is not such a small money. All right. When you find yourself out of those kinds of situations, your reaction can be spontaneous. And I think it was spontaneous. Whether he should celebrate or not, well, if I were his legal counsel, I would not
advise him to do so.
I would no. I think he has a right to. This is a natural instinct that you have somebody coming out of that kind of situation. I would have said to him, look, you can enjoy yourself. Your liberty has been restored. However, the state may want to seek other avenues, which are very, very rocky and a slippery slope for them. And I think it is a slippery slope for the state.
Okay. Dave.
Yeah, so good evening, Councilor. My name is David Tagme. It's a pleasure to meet you. Mine is about the criterion or criteria set. I say criterion because it's criteria is singular and criteria is plural. And mine is about the criterion or criteria set in the juror or the jury selection process. How come people who have no knowledge or have little knowledge about law are allowed to make decisions in such a high-profile case like the one we've just witnessed, and many other cases where people are selected to become jurors, to make decisions in this kind of, kind of high-profile cases? Have you thought about that as a lawyer? Why should people of that category be selected to be jurors?
Maybe I could modify.
Is there a need? Maybe he
Maybe
can
I could modify that question.
Yeah, please.
What is the meaning of jury of your peer? If you are, let me say, for example, you got PhD or in economics or master's degree in economics, and there's a high-profile financial crime issue. In that case, the jury being selected, some of them don't even have high school degrees or high school certificates. So maybe it could be an addendum to his question.
Well, firstly, our system is a common law system. And most of our laws, practices, and procedures are tailored along the United States and other common law countries. The jury system is one we have given thought to over the years. How can it be improved, right? And I think it is now better than it was many years back, because currently you have a jury management system. So you have a unit within the judiciary that is responsible for the activities of jurors, how they are selected, how they come to court. To the best of my knowledge now, the judiciary, that unit, communicates with different government agencies and requests them, parastatals, and requests them to send individuals for jury service. So you are paid by your institution, you go for jury service, and then you get a little token for the time you serve as a juror there. I do not think all of those who go for jury service now are people who are non-high school graduates and all people who do not know anything or who do not understand anything. I think to a greater extent, there is an improvement. I have had interaction in jury trial with many jurors. But yes, the critical question is, do they have the capacity to understand, to appreciate the issues, the facts? Do they have the spine to resist some of the temptations, that come along, with those things? Do they have the integrity, to do exactly what the law is? Because the law says that even when you are jurors, you do not discuss the case until you go into your deliberation room. Until you go into your deliberation room. In this case, the jurors were sequestered. So even where they returned to their place where they were living, they were prohibited from discussing the matter. But how do you protect against that? It's difficult to protect against that. If one juror is more educated, more influential among the others, there's a tendency he or she may have greater influence over others who are there, and his views may be taken, maybe given greater weight and credibility than the views of others. That's a possibility. So when you come to the issue of your peers, the intent of the law is not that if you are a PhD holder, you must be tried by a PhD holder. Because what the jurors are concerned about or should be concerned about are the facts in the case, the facts, not the law. The judge is the one who is concerned and who interprets the law. They are there to look at the witness who is speaking, look at his comportment, his demeanor, his conjecture, and see as to whether what he's saying is true or is false. So it doesn't require a lawyer, it doesn't require a medical doctor to be the determinant of the explanation of someone, whether the person is saying the truth or the person is lying. You do not necessarily require an engineer to do that. So it is ordinary people in the society. Ordinary does not mean that they lack basic education or they lack the fundamental understanding of what happens in the environment. Most of them do understand what happens in the environment. Most of the people who go as jurors today are quite aware about corruption. They are quite aware about how systemic corruption is, how it has eaten the fabric of the society, how it has affected every one of us directly or indirectly. So for them to sit there and come up with a decision, you must ask yourself, I am not trying to give any credibility to what they have done, and I have no authority to question what they have done. You are to ask me, I respect their decision because that's what the law says. Yeah. I respect their decision. But whether there are challenges, yes, there are challenges with the system. But I think it's more improved than it was before. In this case, the jurors were sequestered. In other cases, they are not. They are left to go back in the community each day and return the next morning. What guarantee do you have that they are not being penetrated or they are not being convinced by party litigants? You have no such guarantee. So these are the weaknesses that we find in the system. If we were to improve it, yes, there are arguments, debates to say, let's do away with the jury system. But there's a flip side of it. Do you commit the fate of your client to a single judge as opposed to a 12-man jury in a criminal case? Do you? I would prefer putting it in the hands of a 12-man jury where you have many heads, many thoughts, many considerations. They're put in the hand of a single judge who only needs to think the way he thinks and makes a decision the way he sees it. So there's a flip side about the whole thing. There are some jurisdictions, especially in the United States, that have done away with the jury system because of the flaws it has. So my view is that we need to improve upon the system. We need to work with it to see how we can improve upon it to make sure that the jurors themselves do appreciate their role, because it's a civic duty that they are rendering to the state. When you sit outside there and you say the court, the judiciary, but when you come from among members of the public and enter the court to make a decision, then you are part and parcel of the court process. You have a role to play. So if you went there, it's expected of you to make a decision that you will go and sleep sound and don't worry about what you have done or what harm you have caused on another person, because you are adding insult to injury by that. So it's for us to conscientize the public about jury service. I think there's the need for greater awareness, on why to go for jury service, and that we must think beyond our personal relationship with people.
Okay, Councillor, this follow-up question.
Please,
I beg you. This is a follow-up question.
Dave, go around the table.
Somebody hold your phone.
I got two questions.
Okay, no problem. Okay, no problem. I want to do a follow-up question.
Yeah, no, you later on you do a follow-up question.
Let me ask a question, please. Can I ask a question, please?
Use the microphone. No, somebody's speaking. Please, after this person, I will come to you.
So it's great to have you, Councillor. I mean, it's great to share your legal insight with this ongoing case. But then I want to base on precedents, because most often in our legal system, precedents often referred to as laws, and when these precedents are served, it creates the impression that judge or court rulings can sometimes based on these precedents. So now, given the nature in post-war Liberia, with our reference to the one you mentioned, wherein the government would take a case and then probably do a trial, and then when the verdict comes out, you always get these defendants who are being convicted by the state prosecutor from the hearing will have to take an appeal to the Supreme Court, and probably they will have to win. Yeah. The case with the Gloria Musu-Scott, the state, charged her, and she was found guilty by the same jury trial. And then 1 year after she served at the Monrovia Central Prison, new administration took over, and her legal counsel filed an appeal to the Supreme Court. And they were on a judgment that the state by then never had sufficient evidence to have prosecuted her for the crime, as she was alleged of. So now, given this kind of evidence, also the pieces of evidence, the kind of very precedents, I'm concerned about now with the nature that there might be a new trial. So looking at the evidence of the case, like it has been criminal conspiracy, and we all know criminal conspiracy must have a root, must have a source of origin. Now, the entire case, as per nature, centers around the former finance minister, Samuel Tuah. So now that if the former finance minister, who is the central pillar, into the commissioning of that crime, has now been set free by the verdict of the jury. So I'm thinking, if the court grants the new trial, is there not a wild possibility? Because unless you describe the government taking advantage of the constitutional provision.
Speak to the mouth, please.
Yeah, I mean, I listened to you when you said if the government might take advantage.
What is the question?
Dave, I'm coming. I'm laying some premises. So that will be a very slippery slope. So I'm concerned. Now, Samatua was the main source of this matter, and the government has made it clear that those Samatua have never been a target. So I mean, if given the fact there will be a new trial, is there any possibility for Samatua to be retried by our justice system?
Well, I do not want to agree with most of you and some members of the public who take the opinion that Samuel Twa is a ringleader. I'm not a lawyer for Samuel Twa. I have no reason to speak on his behalf. But it's the public that is taking that view. Because the indictment itself did not name anybody as ringleader. The indictment charged those people and categorize the role each of them is alleged to have played in the commission of the different offenses that was alleged in the indictment.
But it has similar titles though.
Yes. So criminal conspiracy, criminal facilitation, economic sabotage, theft of property, those were some of the offenses that were charged in it. Conspiracy does not mean that there is a leader and there is someone else who is next to him and there is a third person or there is a hierarchy of leadership in the commission of the crime. That's what conspiracy is. Conspiracy is that we all planned. It's either before the fact or after the fact. We plan to carry on this act. It doesn't mean when I join. We plan to carry on this act before it was done. Or when it was done, I got to know about it, I concealed the information, and I participated in the spoil. So it's before the fact and after the fact. It does not name a hierarchy of who is the head, who is not the head, or who is the ringleader. No, it's the public that is given that characterization, possibly because of his position at the time. So as a legal mind, no, I wouldn't want to give it that characterization. And I would not question why the jury rule of why the verdict came out the way it came out, because I am not in the mind. I was not in the deliberation room. That's why I don't want to dwell into that, because there is nobody outside here. It's only the jurors who were there can tell you how and why they derive at the decision they derive at. And for me as a lawyer, I must respect that decision of the court itself. We respect that decision.
Okay, so listeners and viewers who listen to the Nighttime Heat rated on Prom FM 105.5. You can share the live video. We are streaming live on Prom FM on Rover 105.5. We are also streaming live on our Facebook and our YouTube channel. Just tap on Nighttime Heat. And of course, you go to watch the show online. Mr. Sheriff, you can come in with your question.
Thank you, Councillor Abraham Silla. I think I've started to become one of your followers already, for the fact that you come on the platform and speak the law or interpret the law, not on the basis of because you want to turn it to satisfy certain political side. So thank you. Here's my questions. While you are talking, I take down two questions to ask you very quickly. So the first question is, if the evidence against all defendants was identical, but only some were convicted, can the inconsistent verdict itself become ground for appeal or retrial? That is number one question. Number two question has to do with what legal remedy are available if the prosecution attempt to retry acquitted defendants?
If I understood,
Mr. Sheriff, Mr. Sheriff, you can restate your question, please. He's trying to write it down. Restate your question.
Questions, while you were talking, like I said, I took two questions down. I said, for number one, if the defendant against, if the evidence against all defendants was identical, but only some were convicted, can the inconsistent verdict itself become ground for appeal or retrial? That is number one question.
Okay.
You get that?
Yes, yes.
Number two question say, can newly discovered evidence? No. Number two question say, what legal remedy are available if the prosecution attempt to retry acquitted defendants?
Okay. All right. You answer a question. Just listen. Just go ahead.
Okay. Yes. So let me begin with the second question that you asked. What legal remedies are available to the defendants? I will assume you are referring to Samuel Twe and Cooper, who were acquitted. Am I correct?
Yes.
Okay, great. So our laws are quite clear. I think I stated this earlier on. The state can appeal on any two conditions, or only two conditions, and those two conditions are not available to the state in the case of both Samuel Twe and Cooper, meaning that as the verdict is, Samuel Twe and Cooper are deemed to be set free, and when the judge is ruling on that particular matter, he will deem them not guilty in keeping with the verdict and declare that they are ordered not to answer to those charges anymore. However, as I told you, the state may, that's the only route the state has, which I classify as a very, very slippery slope for them. They may want to announce an appeal from that decision, from that judgment of the judge, and the judge may be inclined to deny their appeal. Then they may want to seek a review of the judge's denial of the appeal before the Chamber of Justice. There are so much hurdles that they must cross. They must first be able to convince the Chamber of Justice that they have the right to appeal under the Constitution. And if he agrees or thinks that what they have said makes sense, he may grant them an opportunity to be heard. Or he may think that what they have raised may constitute constitutional matters, which may require the hearing or the full bench of the Supreme Court. Under that circumstance, while that is going on, Samuel Twe and Cooper are deemed free men by the verdict of the jury until and unless the Supreme Court, the state is able to clear those hurdles and get an opinion of the Supreme Court, a judgment of the Supreme Court that the state has a right to appeal for a not guilty verdict. Twe and Cooper are deemed free and never to answer to those charges. That's the first question about legal remedies. So, as it is, our statute laws with respect to a non-guilty verdict do support the case of Samuel Twe and Cooper, and the lawyers are in a very comfortable position to resist them using our supporting laws, both statute and decisional laws. The one you refer to as inconsistent verdict, I would not classify the verdict as inconsistent because I have absolutely no authority to question the wisdom of the jurors. And our court have said repeatedly that where the jurors listen to the facts, the evidence, and make the decision except where you can prove otherwise, the verdict remains the verdict and should be undisturbed. So to say that the verdict of the jurors are inconsistent, I will be careful not to classify it as being inconsistent, even though, there's certain persons are guilty, certain persons hang verdict, certain persons guilty. And that's what the law says. The new jury law says, where there are multiple offenses and multiple individuals are charged, on each offense, the jury must state whether the person is guilty or not guilty as with respect to a particular offense. The juror did just that from what I saw from the verdict form. They determined this man is not guilty. They determined this man is guilty. What informed their decision to derive are those decisions? I cannot say because I was not part of their deliberation.
Okay. All right, Moses, you can come in.
Yeah, thank you. Thank you so much, Councillor Silla. It is indeed a pleasure to get to meet you tonight virtually. I am impressed. I am impressed not because you're speaking or you're saying what I want to hear, but I'm impressed for the fact that you are speaking to the core issues. You're speaking as a lawyer. Now, this is the question I would like to put to you. I want you to speak to this principle of double jeopardy. Legally, I am told, and research shows that when the court rules in a criminal case not guilty, that implies the prosecutor, the state, failed to provide the preponderance of evidence. The state failed to prosecute. So it means it's over with. When a verdict is hindered, it's hindered. It also provides, the law also provides that someone cannot be tried twice for the same crime, because if that happens, it will equate to what they call double jeopardy. For our many people who are listening to you, Counselor, could you please elaborate on this? Double jeopardy with particular reference to this case.
Well, thank you so much. Look, the principle of law that says that the state has only two ways by which it may appeal from a criminal matter or appeal in a criminal matter, and I indicated the two instances. The rationale behind limiting the state right not to appeal from a non-guilty verdict speaks to the issue of double jeopardy. And that's what I say, the extreme route that the state may want to take in order to resuscitate the Samuel Twa issue is a slippery slope. It is a slippery slope because I am with the view that if the state were to be given the right to appeal a non-guilty verdict, it means that the defendant can be tried for the second time whenever the defendant is found guilty, amounts to double jeopardy. Right. And double jeopardy is constitutional. Double jeopardy is statutory. So even if the state were to take that route, I'm with the view it will constitute double jeopardy. And the rationale behind preventing the state, as I indicated, from appealing for a non-guilty verdict is to prevent the harm of an individual being subjected to a criminal trial more than once.
Absolutely.
So under the circumstances, that's what the principle of double jeopardy comes about, and that's the rationale behind limiting the state right not to take an appeal. So let's assume that the state take the extreme route I described. Their difficulty is overcoming the issue of double jeopardy, whether or not that may not constitute double jeopardy if the Supreme Court were to say the state has a right to appeal for a non-guilty verdict. In my view, that will constitute double jeopardy, and I will be very, very surprised if the Supreme Court will ever derive as such a determination.
Okay, you listen to the Nighttime Heat, Radio on Prime FM 105.5. We are streaming live on our Facebook and our YouTube channel. Now, let me ask, I'm sure my colleagues will want to go around the table again, because I'm sure we'll have you up to 10 o'clock and then you can leave. Let me ask this question, and I'm asking you not in your capacity as a lawyer. Yes, okay, as a lawyer, but I'm asking you in your capacity as a librarian who is concerned about the forward movement of the country, the future of the country, the forward march of the country, concerned about governance, good governance, concerned about the fight against corruption. If I could just put this question this way, looking at, yes, you indicated you don't have the authority to question what the jurors did. I agree. But that's what I said. I'm asking you as a librarian. Considering what you know, and you've also been in jury trial before, what had happened, and you spoke about the flaws You spoke about some of the things that happened behind the scene. Do you see the recent verdict? The recent verdict by the jurors in favor of Samuel Twere and the other guy. Do you see it as appropriate or a verdict that resembles travesty of justice? Let me put it up.
Well, Saba, for me to give any characterization to the verdict will be unfair. It will be unfair because I did not give any critical look or examination to the evidence or the pieces of evidence.
But to follow the case.
I did.
You listened to some of the testimonies.
Yes, I did.
And let me just bring it to one of the testimonies. I'm sure we should listen to. Samuel Twere and the rest. Can you play that video for us quickly? Can you get that video out? I know we're coming to this point. Get that video out. The video that has to do with the lead counsel for Samuel Twere, Arthur Johnson. Get a video out here for us. You're listening to the Nighttime Heat.
Good afternoon, Councillor Johnson. Welcome to the media.
Yeah, look, let me just make something very quick and clear. The last time the Solicitor General came here and told you people that the defendants in this case have confessed to the crime, that is a lie. It's not true. No one confessed to a crime. There is a difference between confession to criminality, and making a point. Confession to the crime means the man is admitting to the crimes in the indictment that he committed the offense. That is not the case. What happened in this case is that there is a statutory function, or there were statutory functions that were carried out by the former Minister of Finance. That is under section 14.2 of the Public Finance Law. The law says that the Minister of Finance has the authority, statutory authority, to authorize payments that have been recommended by any of the branches of government within the budget or authorized within the budgetary laws of Liberia. And that is exactly what the Minister of Finance have done. And that payment was made to the appropriate administrative agency that was authorized at the level of the National Security Council by the President of Liberia at the time, His Excellency George Manawia. And so on the basis of this, no one should criminalize when the Solicitor General comes out and says that was confession. That's not confession. Confession is all of the allegations that have been made, yes, we agree, we the one committed. No, there was no crime here. There was a statutory function that was carried out and it had been criminalized. So we want to make that clear. If the Solicitor General agrees with what he said the last time, that the defendants are confessed to the crime, then why are we selecting jurors? So that is to tell you that what the Justice Ministry was intending to do at the time, we call a trial by TV and trial by Facebook. The perception is to get...
Okay, so now we're listening to the lead counsel of Twere and others. Like I said, you follow the case. And the argument, one of the arguments is that what they did was in the interest of national security. Now, there were two top security personnel, two top security officials who went there to verify, to testify whether, yes, indeed, they were also part of the national security arrangements. And they did say that they didn't have any knowledge, Zianka and Prince Johnson. Now, my question again to you, yes, I know you are a lawyer. You follow the case. There were hard evidence, according to prosecution, that the prosecution, in fact, presented. Yet the verdict came the way it came. As a Liberian, take up your gown, your black gown. I'm not taking you to the courtroom. But you one person who concerned about good governance, the fight against corruption. You're concerned about that. Do you see the verdict as appropriate? Or do you see it as resembling what you call travesty of justice?
Well, so yes, you are quite correct. I serve as a public defender.
Sure.
And then I serve as a prosecutor. In many instances, I've prosecuted matters with the Ministry of Justice, with the LACC as well. And I have defended a couple of number of high-profile cases here. The $16 billion case, of course, I was a lead counsel in that case. So yes, I have a good appreciation of what you are talking about. But it is not for me to classify the verdict as a travesty of justice. Because that's what the legal system is. To say travesty of justice is to say that the system has not worked the way it should have worked. In my view, the jurors listen to the evidence. Look, there are two components of the burden of proof. We say the state has a burden of proof, or anyone who alleges. But in a criminal case, the state has a burden of proof. And the standard is beyond into the exclusion of reasonable doubt. But there are two basic components under the burden of proof. One is the burden of production. You have the burden to prove, and that proof means that you must produce the evidence. And that evidence must be beyond reasonable doubt. There must be no other explanation in the mind of the ordinary man sitting as a juror that there is a better evidence other than the evidence you have brought. That's what it means, beyond into the exclusion of reasonable doubt. There will be no other explanation left in the mind of that person. Then you have the burden of persuasion. When you produce the evidence beyond reasonable doubt, then you must be able to persuade the jurors to believe what you have produced. In this case, all I can say is that the jurors believe Samuel Twe and Cooper more than they believe the witnesses of the state. In instances where they had a non-guilty verdict for some offenses against the other two defendants, they believe what the defendants say and did not believe what the state said. In instances where they came down with a guilty verdict against the three defendants, they believe the state evidence over what the defendants said. So the burden of proof must be accompanied by the burden of persuasion.
In another word, are you saying that apparently the state didn't produce?
No, I wouldn't say so. I wouldn't say so. They produced evidence. But
were they not cogent enough?
They presented their case to the jurors, right? The jurors are the only people who can determine who to believe and who not to believe. And so if the law itself assigned to them that responsibility and they performed it and made a determination, I cannot refer to it as a travesty of justice. Until anybody can prove otherwise, I don't think it's a travesty of justice. I think the legal system has worked and should be allowed to work all the time. And that's one credit I think the government should take. Because to allow the system to work in such a matter where the jury came down with a verdict in respect of the fact that they were sequestered, came down with a verdict, no one is being pursued, no one is being questioned as to why they came down with this kind of verdict, no one is being haunted. I think that's a plus for the government to show that the system is working and it must work for everybody. That is the rule of law.
Okay. This
is mine is just very simple. Thank you for discussing all the legal aspect. This trial, you follow it. Did you see or observe at any time where the presidency got involved to say, I want this person to come down?
Well, I am not within the presidency.
Like compared to what happened in the past, where we used to see cases way back during the heydays before the crisis and all that thing.
No, I am not a witness to any one of the situations where there has been interference with the judicial system.
Thank you.
So I cannot say I saw it. I have not been a witness to any one of them, but I'm just saying that the fact that the system has been able to work, where the jurors were free and gave down the verdict, you may not agree with it, but you must respect it and allow the system to work and continue to work. That is the only way. Look, there has to be confidence in the judicial system. If there is no confidence in the judicial system, will result to self-help, and these are some of the contributing factors to the war. You and I, and even the ordinary person, must believe that if I went to the court, I will get justice, even if I am wrong, but I just want a decision to be made because I believe I am right. Let somebody listen to me and say I am wrong. And if the person says I am wrong, I will respect it. I will walk away in peace. That's how peaceful atmosphere is promoted. Unity, stability of the state is ensured. That is the way for us, for us to go.
Okay, Dave.
So my question, Councillor, is that you alluded to the United States, where you said some states have done away with the jury system because of the contention that it continues to generate. Where will you cast your vote? Councillor Sheila, right? Councillor Sheila. Where will you cast your vote if there were a referendum that all Liberians should take a decision of whether or not Liberia should also do away with the jury system? Where will you cast your vote?
For the jury system.
You cast a vote for the jury system?
Yes, yes. I think there is sufficient rational basis for the continuation of the jury system. Notwithstanding, I recognize the challenges it has.
You'd like to name some of the major challenges and how can they be mitigated?
Oh, yes. One of them is just the issue of public awareness. Our people should be fully aware and cognizant of their role as jurors. They should be told to observe integrity. They should be enlightened to know that being a juror, you are not coming to a market. They should know the consequences of making decisions. That when you derive at a decision, it has a propensity to either lead or into chaos or promote peace and stability. They must understand those things. So when it comes from jury service, then they get to understand, even if there are attempts to compromise them, they know they should not be compromised by anybody. So is that awareness that must be created? And I think we can get at that level. As I indicated to you, the system is more improved than what it was, all right, many years back. Because in time past, jurors were just rotating themselves from one court to another court. And they were doing that basically for pecuniary benefits. But now, there are civil servants who are being randomly selected to go for jury service. And the caliber of people I see in the court nowadays is much encouraging in terms of their ability to understand the facts, the ability to know the role of their service, and the ability to make good decisions. I'm not saying every decision they make is good, but that is the role the law has assigned to them, and we must respect it.
Okay. Yes. So quickly, Councillor Silla. I mean,
we have 8 minutes to go, please.
Yeah. So if you were the lead counsel of the prosecuting team, what would have been your most prescribed advice to the government as the party into the case? Now that the government, like you say, might likely want to explore the very limited way and what do you even think that the government should still perceive on this case? Government should still go after the case, considering the fact that one could say the government has won because you have 3 persons being convicted for the crime, just 2 being acquitted. You being a lead counsel to the government for the state, representing the state, what would have been an honest, patriotic advice in the regards?
I do not get advisory opinion. And so I will not give an advisory opinion in a hypothetical situation, except where I had all of the information before me. To come here and say I would have advised the state to do this, and would have given a different outcome, I could just be misleading anyone.
Assuming that you are still the lead counsel, and now that there's a possibility to take to file the motion for what we call new trial. I mean, do you think that would be a smart legal way to go? with the government?
No, the law requires that. The law requires
It
that.
is true the law requires, but it is advisable in this case for the government.
Oh, certainly for those who are were pronounced guilty. I think it's the appropriate thing to do, to seek the avenue. Possibly the judge will see it differently and set aside the verdict and order a new trial. So I think it's the most appropriate approach to take, because that's what any lawyer would do under the circumstances.
Okay, Mr. Sharif, do you have a question?
I think so far so good. I don't really have a question to give the counselor. Like I said,
yes, you already
Moses. Yeah,
Moses, do you have a question? Because we have 6 minutes.
Yes, I just want to say this. Our counselor, critics of this administration, such as me, hold a view that the victory, Samuel 12's victory, indicates that the prosecution failed. They failed because when you say not guilty, it means the prosecutors did not do what needed to be done. If you hold similar view, will you also agree with people who believe that our criminal justice system needs a transformation, given all the challenges you talk about? You know, having individuals coming to serve as jurors that are more like vulnerable. You know, people with limited income, finding it difficult, you know, people who are in survival mode, just trying to live. When you have people such as that on a high profile case like the one that we just had, don't you think that puts the criminal justice system in trouble?
Well, firstly, I do not think I share your view that the prosecution did not do well. And the basic reason is that the work of a prosecution is not to persecute, but rather that is to ensure that justice is done. And justice being done means that you either sustain a verdict of guilty or not guilty. So in other way, in my view, the prosecution wins, because it is a same citizenry that the prosecution is serving. Today, he may prosecute you. Tomorrow, he may prosecute somebody on your behalf. So, on that principle, I don't think I do share your view. The issue about the transformation, the justice system, yes, I think it needs reform. We need to do a lot. Access to justice, promotion of the rule of law, creating awareness among our people, especially in the rural areas, to understand the need to always seek the legal process as a remedy to any problem. The situation you find motorcyclists, setting cars to fire whenever there's an accident is all about lawlessness. Is their lack of appreciation to understand that the accident is not a crime. And if someone is involved in an accident, and that there's a need to help the victim, instead of you braining the car, you should concentrate on trying to help the victim to seek relief. You run behind the driver, you kill the driver, it does not bring back the life of the person that has been lost. So it's for us to be able to create reform in the system, improve the awareness situation, improve the lives of our people, so that they do understand that the rule of law is the best way to seek a remedy whenever you are aggrieved. And if you go to the court moves at a snail pace. So it's good to be patient. It's justice is slow but sure. That maxim is quite correct. No one can get justice in an impactful manner. So I agree with you that there's a need for transformation, but lawyers do not guarantee success. The prosecution go to prosecute. Even the defense lawyers, they do not guarantee success. Because you do not guarantee success, you have not given the state or your principal, the minister of justice, that you must win every case that you go to prosecute in the court. All they can do is to provide adequate legal representation. And if it turned out that the jurors do not believe in the evidence, in their persuasion, and comes the other way around, I think the state wins.
Okay, so finally from my end, before we take leave of you, we heard and read about an instrument, in fact, that was placed on Samuel Tuah and maybe the rest of his accomplices, let me put it that way, which is the new ex-Republican. Now that he has been acquitted, does the state still have the authority to keep it on him, or it is lifted now?
No. In the first place, it is not the state who placed it on him. The state made an application to the court, and the court granted that application for the new ex-Republican.
Okay.
Now that there is a non-guilty verdict against Samuel Tuah and Cooper, when the judge is rendering his judgment, the judge will then order the notification of that new ex-Republican, restoring their rights to leave, enter Liberia anytime they want to. So the rights will be restored when the judge renders a judgment. The bond that they posted, the judge will order the clerk to return their bond to them.
So as we speak, that new ex-Republican is still in effect. It's still in effect.
It's still in effect. It's still in effect until, because the court is the one who orders it. The court is the one that will revoke it and issue the appropriate certificate to Tuah and Cooper in respect of that matter.
Any final words? We'll get the leave of you.
Yeah. Okay. I want to say several things. I think for such an interview, this is my very first time.
I know.
Yes, coming to the studio. I always love to keep quiet and and keep behind the scene. But I know you and I have been talking about this a couple of times, and because of the nature of attention that this matter has, attracted in the public, and the different opinions that have come about as to the continuation of the matter, what right the state has, whether the state can appeal, and the rest of them. So I thought it necessary to come, and I hope I have played my part by providing some clarity, to the issues. You can be assured that I'm available at any time, to come in and provide clarity on some of those issues. I always love to do it in a non-partisan way, in a way that I would just serve the public and provide my own legal knowledge and understanding of the law to the public, other than coming in the defense of a particular party. And so I love to do that defense in the courtroom, other than in the studio.
Thank you very much.
Yeah.
We really appreciate your time tonight.
Yeah, thank you.
Frankly, I want to appreciate you personally.
Thank you.
You're very excellent.
Thank you.
All right, just a team song, and then we'll come back with
Let's start.
Okay, so welcome to the program. Welcome back. Our guest has just left. We need to do our own takeaway and hopefully open the lines for you who want to also make your comments. Because this is very important. We started that yesterday. We had Councillor Jerome Verdier. He too had his own perspectives on the whole case. Tonight we brought in Councillor Ibrahim Sila, another astute lawyer. And so, gentlemen, let me hear from all of you across the floor, beginning with Moses. Moses, what's your takeaway so far from what you heard from the councillor?
Well, I would just like to reiterate what I said earlier.
Moses?
Yeah, are you hearing me?
No,
are you hearing me?
You are low.
Oh, okay. Yeah, do you hear me now?
No, you're still low, Moses. Okay, maybe you can.
Okay, do you hear me?
While we go to somebody else.
But do you hear me?
Yeah. So far, the council are very careful. As he said, he tried his possible best not to sound as if he were backing or supporting a particular faction of the crisis of the case we're talking about. You are very realistic. In fact, you are more educative. than political. He's actually a lawyer, a very honest one, looking at the issues from a realistic point of view. His analysis or the education he provided did not in any way align him with any of the parties in the case, the government or the Samoa party. So I mean, I applaud him and I appreciate him, and I learned a lot from him in terms of his analysis.
Okay.
Yeah, so Councillor Sida wouldn't have said it any much better. One of the key things that I took away is that he acknowledged the fact that the case is not over yet. That's one of his acknowledgments. And he also pointed to the fact that though the case is not over yet, but the government also has a very slippery slope in terms of winning this case, because the possibility of even the judge to deny them access and then taking the filing an appeal to the Supreme Court to investigate the decision of the judge to know as to whether it was done in good faith legally. So there's a whole lot of different mixed reactions, and I will continue to say this, like you asking rightfully that this case, just as it is not concluded yet, and I still hold a view that former Finance Minister Samuel Tuer, there is not a sufficient reason why he should feel that he is a complete free man for good. But I mean, the councillor was clear and tried to speak to some specific legal education, which I think is very necessary for this kind of discussion. And I would like to appreciate him for providing those pieces of knowledge that we all can benefit. So it was great to have him.
Okay, Sharif, let's hear from you. Your takeaway?
I think the councillor was fair in his analysis.
Hello, Sharif.
And most especially stick. Hello?
I don't know what happened to Sharif and Moses. George.
So, I asked the councillor a specific question about that 1972 act that limits the authority or the rights of the prosecution to appeal, because that act is older than the 1986 Constitution, and the Constitution says any law to the contrary is not involved. That particular act has not been tested, and he admitted yes, it hasn't been tested. To try to test it, but it was in a different form, So, but they never really tested it. So this time, people are going to test it because the Constitution is clear that any law to the contrary is not involved. Article 20A allows for all parties in the Constitution to appeal. So when they test it, we're going to see what happens. It will be a learning curve. So the councillor was very, very good. And I seen a technical political question, because there are some people that say, oh, the government want to go prosecute Tuer. And definitely he said, no, it wasn't Tuer. It was the people that were charged. Everyone in the same. They were charged the same crime. So anyone then found guilty, they bear the full consequences of the crime. So it was not like specifically going after Tuer as president. So I think he was very good.
Okay, Moses, are you loud now? Can we hear your takeaway, Moses?
Yes. Do you hear me now?
You're still low, Moses.
Yeah. Do you hear me? But I'm here.
Okay, go ahead. Yes.
Okay, do you hear me?
Yeah.
Okay, so I want to say the councillor did a very great job. He was balanced. He came across as polished. He knew exactly what he was talking about. I think his analysis were very good. I hope our people were able to learn from him. He reiterated continuously that, hey, the chances for a retrial, the chances for Tuer to be held liable, the chances are very slim. I think the government just has to move forward, because the jury has ruled Tuer is a free man. They got to take it. Like we say in the United States, they got to what? Bite the bullet. That's it. Thank you.
Well, I think my takeaway, and that's the reason I asked the question about the two, when he made mention of the two grounds on which the state can take an appeal. And he made a reference to the 1986 and the 1972 statute. I think from what he explained, there's still grounds for the state to hook Samuel Tuer. And he put it rightly. If, let's assume, the judge maybe heard whatever appeal for retrial and or denial or whatever it is, and they went to Supreme Court, the Chief of Justice can look at the whole case in the totality, and at the end of the day, who knows? Samuel Tuer may be still hooked. So let's see the legal drama as it plays out. But for one to say the state doesn't have a ground, or the state has a slippery ground, and I don't want to agree, because this is Liberia, and the state is acting on the laws of the country, and likewise the defense. So let's see what happens, how it plays out. So, gentlemen, let me try to open the lines quickly. Yes, we had a very good. Was it lunch or dinner? Dinner from
legal
dinner from the chancellor. Yeah, Councillor Sila, he did extremely well. He drilled us through, and we really appreciate it.
But
let me just announce the numbers quickly. 0778-460-793, or just call 0778-460-793, or 0776-540-987, 0776-540-987, or 0778-460-793, 088605. Okay, that's the number is not in existence, but you can call this one 0778-460-793. Again, 0778-460-793, or 0776-540-987, 0776-540-987, and then you make your input on the program. Yeah, Moses.
Yeah, I was saying that the counselor repeatedly reminded Liberians that, hey, if the government chooses, or the prosecutors, if they choose to go to court, they will be treading a slippery slope. The chances of winning very slim, and he made reference to, yes. Okay, yeah. Okay, yeah. Let me stop.
Yeah. It's on. Hello? Hello?
Yes, hear me. I'm Gabriel Yanti. I'm calling from Mama Point.
Let's hear from you, Mr. Yanti.
Yeah, so case of retrial, or these guys carry, how to call it, doing the how to call it, appeal, and then somebody decide to point out, say, well, we had the money, and this is what we did with it. And even point out some they call the former finance minister's name, and the other person that they divided the money. Why can they be hooked?
Yes. So it's a very good question you
Hello?
have, but the counselor would have been the right person. Yeah.
We'll try to.
That's my concern.
Yes. Okay. We'll try to note your concern and see what we can put it to another counselor another day. But we note your concern. Rest assured. Let's get another call on the line quickly. 0778-460-793, or 0776-540-987. Again, 0776-540-987, or 0778-460-793. Let's hear from you quickly. Good evening. Yes, hello.
Baba.
Yes, sir.
Thank you. Let me say good evening to the studio guests. And this is Koyung William Bobby, and I joined this conversation from the secretary as a member of the United Party Intellectual Bureau. So my question to your studio guest is that what is the difference between this Samuel Tuer case and the other cases, like, for example, the former defense minister high prosecution of John prosecution, right? Between him, the former defense minister, his deputy, and the other, right? And when the court found them guilty, they found other than guilty as one. Because for me, I know that that is sense of joint prosecution. If one person is acquitted, it means all the others will be acquitted. But if one person is guilty, it means all the others will be guilty. It happened in the case of former Defense Minister Brandon Samuka. It happened in the former Central Bank Governor Milton Wills, Jabba Haba, or Charles Sirleaf, and others. When those people were acquitted, all of them were acquitted. They did not find a single person guilty and acquit the others. All of them were acquitted from that charges, and they were found not guilty. And when it comes to the Defense Minister, all of them were found guilty. A single person was never acquitted from that. So what is the differences between those cases and this case that they have to, it's joint prosecution. Some have to be convicted and some have to be acquitted. What is the differences between them? I really want to know.
Okay, all right. We'll try to note. We'll try to note up your concern. But I think if the lawyer was here, he would have indicated that it has to do with the caliber of jury, that they had at the time, because the jurors, they made the decision. They came up with a verdict that this person is guilty and that person is not guilty. 0778-460-793. Again, 0778-460-793 or 0776-540-987. Again, 0776-540-987. That's the numbers to call, and you are live. We had as guest Councillor Abraham Sila as our guest. He was here earlier. Let's take this call on the line quickly. Good evening.
Thank you, Mr. Sobo.
Yes, sir.
To your panelists and thank to your guests for the recognitions for the public. I'm Poka Robert, and I told you this evening for our unknown destinations. Your service.
Why your destination always unknown? Eh?
No man, go ahead.
Poker.
The man go.
No, the man go over.
On new destination, ain't get signal.
The guy doesn't have signal. Maybe he's calling from in the bush, maybe somewhere deep into Lofa County.
Or into a living room.
No, 0778-460-793 or 0776-540-987. That's the number to call, and you are live on the program. We want to hear your take about maybe let's hear from you the verdict that was handed down by the jurors, saying that Sabatua is not guilty. Rather, they found guilty the other people. Let's hear from you. What do you think about that tonight? Our guest was here. We had Councillor Sila, Abraham Sila, and he did extremely well. Let's hear from you. What do you think about the verdict? 0778-460-793 or 0776-540-987. Again, 0778-460-793 or 0776-540-987. That's the numbers to call, and you are live right here on the program. Let's hear from you what you think about this case, involving the case regarding the economic sabotage. What's your take about the verdict? How do you see the verdict? Do you agree with? Although yes, indeed, it has already been done, but do you agree? Do you accept it? Do you think that should have been an appropriate verdict to set Sabatua free, or you think the jurors slipped, in making a decision? 0778-460-793 or 0886-05 0886-05 0886 the 05 number is off. Let me announce this other number: 0776-540-987. Again, 0776-540-987 or 0886 050507. Okay. Now, Dave, let me hear from all of you on this one while we are with callers. Especially, I want you to be honest. You are a panelist on the program. You're concerned about the future of our country, and every government that came in always campaign on the issue of the fight against corruption. When the verdict was heard, what did come to your mind?
Well, what did come to my mind is that there seems to be fairness in the justice system now.
Okay.
Than it was in the past. And I said this yesterday, the fact that a major opposition politician, former Finance Minister to have been exonerated in such a high-profile case under the Unity Party government. What came to my mind is that public confidence is not being restored in our justice system. And Sametwa himself, I believe, has confidence in the justice system following his acquittal by the court.
Has it happened before? Is this the first time?
Well, for a very long time, I haven't heard
in
that.
high-profile cases?
For a very long time, I haven't heard that. The last time I know of, politicians on the other side of the coin, 6 years ago, as far as I'm concerned, no opposition politician went to court in the past 6 years. That won a case that was even acquitted. All of them were found guilty. Even government lawyers stood in public and said that one will jail her. So, so the latest development as this concerns the Tamatua's acquittal, that shows that there's some little improvement. Our justice system is getting on the right trajectory. The fact that the process was transparent.
Under the rescue administration.
What?
Under the rescue administration.
No, don't put words.
Okay, let's
don't put words.
But obviously, the government will take the glory of it. You acknowledging that the judicial system is fair, so who takes the glory?
That's what let's
So, but truth be told, when the verdict was handed down, what came to my mind was that a judgment was served. Justice was served. Justice prevailed. And I really do believe, and I still hold the view strongly that that verdict was nothing else different, but was exactly what the jurors in their wisdom, based on the evidence provided, ruled. So I think we should honor it. And my little disappointment.
Let's take this person quickly before you continue. Yes, sir. Let's hear from you. Let's hear from you. Okay.
And let me say thanks to the councilor. We have learned a lot tonight. Yeah, seriously. For too long, we have cried for justice in this country. So no matter who is involved, when justice is served, we should commend the court.
Okay.
Instead of blindly criticizing because we want somebody to go down at all costs. For me, it is not right. Now the thing is, the state is more powerful than an individual. The state has all it takes to prosecute individuals. So when the state know that they don't have sufficient evidence to prosecute somebody, they should not go to trial. But once the state goes to trial and doesn't win, we can be kind of, we should try to refund and our system so that the court can treat a few other ones. Do we want the state to appeal against us? Do we want that? Only because we want somebody to go down off us?
Okay.
So we all know that the state is more powerful. So when the state goes to trial and doesn't win, that means justice itself will let it go.
All right. Thank you. Thank you.
We should stop that.
Okay. Thank you. Made a point.
So this is what baffles my mind. If the government has provided a case that they have never at any point in time targeted former finance minister Simon Twa, then the question is, why now that the government has spoken through the ministry, or better still, the Minister of Information, describing the case as the case is not over yet? So to what extent will the case be over is when Simon Twa is guilty?
We're not going to go off tangent.
So honestly, I felt discouraged.
When the verdict was ended up.
I like to say this. I felt discouraged. I felt that probably the jury didn't follow the case, but I respect the ruling.
Mm-hmm.
I respect their verdict. What happened is we can all hear some people say, no rule of law, but this is the rule of law. When the court rules, when the jury takes decision, people respect it. People should respect it. It's just that this crisis now that is between Article 20A and the 1972 Act, that's why maybe when it's tested, then we see what which one the Supreme Court will say is the real one, But I think that it is good to test the judicial system. Where Mr. Tuer is, he feels happy. I know in his mind, he feels that, I can trust the court system. And if that kind of feeling be in the opposition, people see themselves as opposition, they feel that even in the future, when there are election cases, when there are other issues, they can trust the court and the court will give them judgment, justice. Yeah.
Okay.
So it's good.
Moses, let's hear from you. Okay, before Moses, let's take this other caller quickly. Hello, good evening. Good evening. Okay, the call is off. Moses, when the verdict was handed down, Moses, what did come to your mind?
Well, what came to my mind was that the prosecutors, the state, like one of the callers said, the most powerful, failed to perform. That's what came to my mind. And that's what I'd like to say. One of the foremost challenges we have in Liberia is our inability to adhere to the rule of law. We have 14 years of civil war because of our inability to adhere to the rule of law. Mr. Weah-Kane, we saw a violation of the principle of the rule of law. Ellen Johnson Sirleaf, we witnessed the same thing. The Barker administration, we are witnessing the same thing. We need to be a country of laws, but our leaders always come across as a country of men. You live in the country, you know what is happening there. One of our foremost challenges, our inability to respect and abide by the rules of law. That's what I would like to say.
Okay. Gentlemen, time has cut off us. We've got 4 minutes left. But this case continues, which we all know. And like I said earlier, we'll have to follow the drama continuously to determine where it ends. Like you heard from him, I asked about the new exit Republican. He said, well, it's still in force. It means that the senator and the rest of them, they can't travel out of the country because that was prayed for by the state, and the court granted that. And so from what I see, this case is not ending now. It's not ending soon. Yes, despite the verdict by the jurors, there's still room for the prosecution to continue with the case and achieve its objective. And what the prosecution is trying to achieve is to be able to recover the $6.2 million. So I see that there's still effort by the prosecution. In fact, I've been doing my own investigation. There may be a motion from the prosecution, asking for retrial, asking the court to set aside the verdict, because the prosecution still believes it provided all of the hard evidence. We heard, 2 top defense officials, security officials, who appeared in court and said, "Well, we are oblivious. We are not aware of wherever the money went or whatever the money was spent for." So the court still feels it has the case. It has all the evidence to show, and it has the intention to win the case. So let's follow and see how it ends. On this note, Dave, let's get your party comment quickly.
Well, my party comment, but I don't want to get it changed because I think I have limited time. Look, I'm disappointed in Moses. He's too low to have said that he has $1,000 to give to anyone who proves that he is a member of the CDC or any political party. he sounds impressionistic. That is being impressionistic. The fact of the matter is that, look, Moses, look, this is an intellectual discourse. And I continue to tell you that if you have a thin skin, you don't belong here. Stop being emotional. Deal with the issue, Moses.
Why you want to use a party comment?
No, that's my party comment.
I
have the right to say that, Moses. Moses too low to have gone that far. He has $1,000. He hasn't proven that George Kennedy, David Tagbe, or Edwin family have any alignment with the ruling unit. He hasn't proven. But he always aligning up with the ruling
that's a party
because
comment.
of our views.
That's a party comment. Moses, can we get a party comment?
So this is absolutely laughable. You know, when someone speaks, you know, when someone throws gibberish at another person, and you want me to stoop to that, it's absolutely laughable. Mr. Tagbe King, he was very condescending. Mr. Kennedy King, he was also condescending. And let me reiterate again, I am not prepared to stoop.
That is wrong English. Read again.
My man, listen.
There's nothing about read again. No. We're about to close. No, this is a man who says he educated. No, how can he educated speak wrong English?
I'll have to mute him.
No, that's
you
wrong
spoke,
English.
but you spoke. Let the man speak. Moses can come.
You know, let me send David Tagbe to school a little bit. Tagbe, let me tell you, when people speak in structured environment, they don't talk that they are sitting under the palm tree where everybody talking together. No
excuse. I agree with that. That's
so I want you to take that. And let me say this. Our Moses Seni is not a perfectionist, a human being. I am liable to making errors. I am not infallible.
Okay.
So if I spoke, I made an error, that's nothing to wrong with, because you, David Tagbe, is also infallible. None of us on this platform here is infallible.
I agree.
When we come here, when we come on an intellectual forum like this, we come to educate, but not to put one another down. And that's what I see from you guys. You come across as dismissive, disrespectful. And let me tell you, the Moses Seni you knew yesterday is not the Moses Seni today. There's a huge distinction between the Moses Seni of yesterday and today. Let me just stop there. It was a pleasure being here, gentlemen.
Thank you. Right.
Okay. Yeah, no. So it's great to be here always, and I mean, many thanks to our listeners and our viewers. It's great to have this kind of interactions. And let me say this. So that's why I strongly want to disagree with you that when you say, "Oh, the prosecution," I think you said it that the prosecution has won a case. You know, I don't believe that.
No, I didn't say it has won.
So. Okay,
I did say
okay.
The prosecution was able to submit and provide all of the hard evidence.
Okay, so whatever the case is,
the prosecution did extremely well.
Granted.
It is just that apparently the jurors acted not following the facts.
So I listened to a lot of people saying that the prosecution never targeted former finance minister Sam Atua based on a political alignment. But from the look of things, honestly, the way in which that we're becoming to see the government response to the entire thing, I would say clearly that the government, in my honest opinion, I think that the government believes that she lost the case. And it is because of that the government still trying to hunt on this case to make sure that those who they believe in her mind that should be convicted for the crime are being acquitted. So two ways. It means that the government still don't believe the government does not accept the government does not accept the verdict from the jurors as fair or transparent. I'm not too sure the government accept that. If the government has done so, the government don't know. There'll be no news about what we call fire motion for new trial. You know, the government. If it is also about the issue about restituting the 6.2 million. Oh, come on! There were people who were convicted. So once the case is being concluded and you have people who were convicted, The government should go after the people that they arrested, the 7.2 million, because according to the ruling that the people who should be accounting for the money.
Okay. All right. Let's get the pattern coming, George.
So we hear a lot of people make statements on the show. That's why I said, Sobo, I beg you. Some of these statements we should be cutting it so can be replaying, like what sometimes Spoon can do when you lied. You say they didn't say so, they play your voice, you listen to yourself. And you know, I'm very happy that even Mr. Sandy has said that he's a critic of this government. Even though other times he said he voted for the government, he supports the government. Those contradictions, when I'm hearing it as a journalist, I put you in a state of someone who it cannot be believed. You cannot be believed. You know, as a journalist, you should trust the newspaper believability. You know, so if every time you flip flopping, I see that, and you and someone on the show when they try to take you on, you say the person that ruling party person. When they come after you, you say the person was condescending. This one word, I'm tired. I think what we need to do, in all fairness, if Mr. Sandy has $1,000 to give, he can donate it to the show.
Okay.
I think we need Starlink. You can buy one Starlink and say here, the subscription can be able to pay the subscription on this side. But I don't need it for myself from you. I said, well, maybe from difference on it because I'm here, like bro, we're struggling here, but the little I can get, I'm
all right, thank you
very much.
Gentlemen, I want to thank you for the day. I think we had a splendid discussion, and thanks to our student guests who came in. Councillor Abraham Sila, he did extremely well. Until tomorrow, Sobo George is my name. Have a splendid and restful night.